Hello, my name is Sophia Kruszewski, and I'm the clinic director at Vermont Law School's Center for Agriculture and Food Systems. And it's my pleasure to welcome you to this presentation about farm reorganizations under Chapter 12 of the Bankruptcy Code. This project is a joint production of Vermont Law School's Center for Agriculture and Food Systems and the Association of Chapter 12 Trustees, with funding from the National Agricultural Library at the U.S. Department of Agriculture. The Center for Agriculture and Food Systems at Vermont Law School uses law and policy to build a more sustainable and just food system. We cultivate future leaders and empower food system stakeholders through education, research, and collaboration. Our work spans the food system, from farmland acquisition to food production, distribution, access, and surplus, and ranges from providing direct legal services to farmers and food producers to developing recommendations for a coordinated approach to food system policymaking in the U.S. And as a result of our work, we are acutely aware of the significant need that exists among farmers across the country for skilled legal and technical assistance in transitioning or transforming the farm to adapt to a range of challenges and opportunities, whether economic, environmental, or otherwise. Chapter 12 reorganization is an important part of the toolkit that lawyers and other ag service providers can draw on to provide this assistance, but it's underutilized. So our goal for this presentation is to share information to help overcome some of the negative connotations associated with bankruptcy, to demystify the process and benefits of Chapter 12 reorganization, and to discuss not only how Chapter 12 can serve to help farmers avoid or recover from financial distress, but also how it can serve as a tool for farm transfer and transition. We're pleased to be partnering with the Association of Chapter 12 Trustees to make this presentation available for free to attorneys, law students, and other professionals who work with farmers. And with that, I will turn it over to the Honorable Judge Colleen Brown, the Chief U.S. Bankruptcy Judge for the District of Vermont, who will introduce our distinguished panel.
My name is Colleen Brown, and I have served as the sole bankruptcy judge for the District of Vermont since April of 2000. In that capacity, it has been my honor to preside over dozens of Chapter 12 farm reorganizations. Chapter 12 is unique, and my co-panelists and I would like to spend about 45 minutes today explaining to you how that's so, and also the many ways in which Chapter 12 can be used, and why it is crucial for bankruptcy professionals to be familiar with it. Essentially, I'm going to give you a little preview of what's to come. In my experience, both representing farmers and presiding over Chapter 12 cases, I have observed that individuals who choose to be farmers have deep wells of optimism and courage, ingenuity and innovation, patience and persistence. These are essential traits as these individuals face the unpredictability of the weather, the potential of their animals being infected by disease and their crops being attacked by insects or toxins, the fluctuations in governmental programs, and the volatility of the market for agricultural commodities and the economy generally. Farmers are affected by far more uncertainty than most, if not all, other types of professions. Yet they persevere and provide all of us with beautiful, abundant, and nourishing food. Essentially, Chapter 12 is the congressional recognition of the crucial role farmers play in our society, and it offers tools to all attorneys who counsel individuals and corporations in financial distress or advise entities in the agricultural sector. All of them need to understand Chapter 12, and here's why. First, Chapter 12 is much faster and much less expensive than Chapter 11, and far more powerful and flexible than Chapter 13. It also offers a myriad of outcomes. For example, in Chapter 12, a farmer may restructure its corporate or financial system, modify the nature of their farming operations, pass the farm on to the next generation, intentionally downsize, or exit from farming in an orderly manner. And Congress built in extraordinary relief from capital gains in the event of sales of farm property in Chapter 12. Second, even more than other chapters of bankruptcy reorganization relief, a successful Chapter 12 reorganization almost universally benefits not only the farmer, but also the farmer's employees, creditors, and community. The nature of the relationships between farmer and vendor and between farmer and customers is a central focus in Chapter 12 because they all share a deep understanding of the nature of farming, how precarious it is, and how vulnerable the farmer is to circumstances beyond their control. In Chapter 12, it's typical for many constituents to be actively engaged in the case and usually supporting the farmer's reorganization and weighing in to assist in the process. While creditors do not have the right to vote on or control confirmation of the plan, they can file an objection in an effort to improve the treatment of their claims or press for a more viable plan. They can also provide essential historical and financial data to the farmer to aid in the formulation of a plan and to inform the court when disputes are litigated. Third, in Chapter 12, a farmer gets the time and space free from creditor pressure to formulate a plan for moving forward, arrange to pay their creditors over time on flexible terms, and get a fresh start. Fourth, Chapter 12 has a much higher success rate than Chapter 11, and in many districts, higher than Chapter 13. I'm pleased to tell you that Vermont has a high success rate in Chapter 12 cases. I attribute that to the commitment of our Chapter 12 trustee to the confirmation and completion of each case, the availability of debtor attorneys who have deep bankruptcy expertise, and creditors and their attorneys who understand how powerful and valuable Chapter 12 reorganizations can be. This is a combination that can be cultivated and achieved in any district that understands the value and mechanics of Chapter 12. Finally, I'd like to introduce you to the cast of characters in a Chapter 12 case. It includes 6 major roles: the debtor, the debtor's attorney, the creditor, the creditor's attorney, the trustee, and the judge. We don't have a debtor here to speak to you today, but we do have a representative from each of the other 5 categories. I will introduce them briefly. Jan Sensenik has served as the Chapter 12 and 13 trustee in Vermont for nearly 30 years. In that capacity, he has been the trustee in Vermont in every Chapter 12 case ever filed here, and he is currently the president of the National Association of Chapter 12 Trustees, otherwise known as ACT2. Rebecca Rice is a Rutland, Vermont-based bankruptcy attorney who generally represents debtors and specializes in Chapter 12 and 13 cases. She has been practicing bankruptcy law for over 30 years and currently represents the debtor in 32 of the 34 Chapter 12 cases pending here. Peter Fitzgerald is the Director of Loan Resolution for the Vermont Economic Development Agency and has been involved in the majority of Chapter 12 cases filed in Vermont. He has seen Chapter 12 cases from the lender and creditor's perspective and has a keen understanding from that vantage point of what has worked and not worked in particular approaches used in Chapter 12. He can tell you why Chapter 12 is beneficial to lenders and creditors as well as debtors. Brittany Ogden is a creditor's attorney from Wisconsin with extensive experience in bankruptcy, farm reorganizations, and Chapter 12. And with that, I will turn the panel over to our next speaker.
Thank you, Judge Brown. I'm Jan Sensenik, and I've been Vermont's Chapter 12 trustee for almost 30 years now. And it's my privilege to talk to you about Chapter 12, a little bit of the history and some of the great features about Chapter 12 and why I believe it's the most powerful chapter in the bankruptcy code. Chapter 12 started in the 1980s as Congress's response to a very severe farm crisis then that involved falling land values and grain prices combined with skyrocketing interest rates. During that period of time in the 80s, farmers were going out of business in record numbers. And that's when Willie Nelson started the first Farm Aid concert, for those of us old enough to remember the 1980s. And farmers were driving their tractors in protest to Washington. And so Congress responded in 1986 by giving farmers what is, I believe, the most powerful financial reorganization tool the country's ever seen. And the success of Chapter 12 as a temporary measure led eventually to 2005 when Congress made it a permanent part of the bankruptcy code. So why is Chapter 12 such a powerful reorganization tool? Well, let's compare it to some of the other reorganization tools in the bankruptcy code, notably Chapter 11. Now, Chapter 11 is largely credited with saving the American auto industry in the recession of 2008. But even Chapter 11 doesn't really come close to the power and efficiency of Chapter 12. First off, Chapter 12 is much more streamlined. It has simpler plans and no long, complicated disclosure statement to file. And very importantly, there is no voting on confirmation in Chapter 12. A bankruptcy judge can confirm a Chapter 12 plan over the objection of creditors as long as the court finds that the plan is feasible, it's based on reasonable valuations and treatments to creditors. And importantly, only the farmer debtor in Chapter 12 can file a plan. Creditors can't file a plan in Chapter 12 as they can in Chapter 11. Now, Chapter 11 also has something called the absolute priority rule. In this rule requires each class of creditor to be paid in full before any junior class of creditor can retain any equity. This makes it very difficult for owners of businesses in Chapter 11 to retain property unless they fully pay their unsecured creditors. There is no rule like that in Chapter 12. In Chapter 12, some plans pay little or nothing to unsecured creditors, and yet farmers are still able to retain their land at the end of a plan. And finally, Chapter 12 has a much higher success rate nationally than Chapter 11. With most cases succeeding in some districts much higher than 50%, nationally higher than 50%, and in some districts much higher than 50%. So then let's take a look at the Chapter 13 and compare it to Chapter 12. Chapter 12 is simpler and more flexible than Chapter 13, and Chapter 12 has many advantages over Chapter 13. First off, the debt limit in Chapter 12 is $10 million, which is 5 times that of Chapter 13. In Chapter 12, the plan is not due until 90 days after the case is filed, which is 3 times longer than Chapter 13. And plan payments aren't due until after confirmation, as opposed to 30 days from the date of the filing of a Chapter 13 case. Importantly, plan payments in Chapter 12 can be structured around a farm's cash flow cycles. And that could be monthly, or it could be seasonally, or even annually, depending upon how the farm operates. Plans in Chapter 12 allow the payment of secured creditors over a period of time that's longer than the life of the Chapter 12 plan, and sometimes even longer than the life of the loan itself. Chapter 12 allows the modification of rights of holders of security interest in real property that includes the debtor's principal residence. That's very different than Chapter 13, where modification of home mortgages is impossible. In Chapter 12, literally all of the secured debt of a farm, including the home mortgage, can be rewritten from scratch based on a competitive interest rate and based on the value of the property, known as a cram down. And that's a huge advantage in Chapter 12. There are two other really large advantages Chapter 12 has over both Chapter 13 and Chapter 11. So let's take a look at that in the next slide here. These sections are 1206, which is the sales provision in Chapter 12, and Section 1232, which talks about deprioritizing gains taxes. So let's take a look at those, starting with Section 1206. Section 1206 is, I would argue, the most powerful sales section in the Bankruptcy Code. This section allows for sales of farmland and farming equipment free and clear of liens of creditors with liens attaching to the proceeds. What this means is a sale can happen even if the sale doesn't produce enough money to fully pay off the secured claim for which the property is collateral. And under this section, creditors are not required to consent to the sale as they are in other chapters like Section 363. Sales can be all or a portion of the collateral for a loan. And while they're done by a trustee, these kind of sales are determined by and chosen by the debtor and incorporated into the debtor's plan to benefit the debtor based on the debtor's needs to change the scale or size of the farm. And finally, sales through 1206 done by farmers often can maximize the proceeds of sales rather than auctions and forced liquidations by creditors. And so maximizing those proceeds helps both the debtor and the creditors when that works in Chapter 12. So let's look at Section 1232. Now, this is a fairly new provision of the code and a very powerful code, and does something that doesn't happen anywhere else in the bankruptcy code. Section 1232 allows a farm debtor to treat the gains taxes resulting from the sale of farm property through a plan as non-priority, unsecured, dischargeable debt. What this means is when there's normally capital gains taxes occur on a sale on a property in a bankruptcy case, the gains taxes must be paid in full in the plan as a priority claim. Section 1232 changes that to allow those gains taxes to be treated as a non-priority unsecured claim and be paid only a portion depending upon what the pro rata distribution is to other unsecured creditors. It's essentially putting it in the same pot as the feed bill and the grain bill and other types of unsecured debt. And this is the only place that this occurs in the bankruptcy code. And when it's done this way and its plans succeed, whatever amount doesn't get paid can be discharged at the end of the plan. And so this section alone can save farmers hundreds of thousands of dollars on the sale of property through a Chapter 12 plan. So with all this power, you would think there would be a lot of Chapter 12 cases for farmers. But in fact, although the estimates are that there are over 2 million farms in the United States, in the year of 2020, there were only 552 Chapter 12 cases filed. That's approximately 0.00025%, a very small percentage. Why is that? Well, one theory is that many farmers don't know that Chapter 12 exists. And probably a lot of attorneys aren't aware of the power of Chapter 12 or how it works. And obviously many people assume that a farm bankruptcy case must mean the end of a farm or the liquidation of property, when in fact in Chapter 12 it's just the opposite. In reality, Chapter 12, for all of these reasons that we went over, is really a very powerful tool for keeping farms in business, and so that's the reason really that we're sort of making this presentation, so that more farmers and more attorneys can find out about this tremendous power in Chapter 12. And so the next question is, who's eligible for Chapter 12? And to address that topic, we have one of Vermont's preeminent debtors bankruptcy attorneys, Rebecca Rice. So Rebecca, take it away and tell us about eligibility.
So the first thing you need to do when you're meeting with clients and wondering what chapter they should go into, or particularly if they qualify for Chapter 12, is the definition of who is eligible for Chapter 12, which includes only a family farmer or a family fisherman with regular income. Now, regular annual income does not currently need to be from the farm or the fishing, but there needs to be an ability to make a regular monthly payment. Farming activities can include your standard crop products, raising corn, hay, raising of livestock or poultry or livestock products, Christmas tree farms. I had an alpaca farm, orchards, vegetable farms, lots of different types of farms, except that generally horse farms where the primarily focus is giving riding lessons don't qualify as farming, because that's providing a service rather than raising something. Farms that do have raise horses or raise and train horses for sale, those would probably and do qualify under Chapter 12.
See,
Now, to be a family farmer, the debts can't be over $10 million, which is as of 2019. It used to be considerably less, in the $4 million range. But at least 50% of the farm debt is farm related, not including the home mortgage, unless the mortgage is a farm mortgage. And more than 50% of the debtor's income is from farming. Now, that doesn't have to be currently from farming, but it has to be either the previous 2 years, more than 50% of the debtor's gross income is from farming, or the current year. I've had several cases where borrowers have gotten out of farming a year or two prior to filing, but because their income during the prior 2 years was more than 50% from farming, they qualified for a Chapter 12. If it's a family farmer, at least 50% of the shares need to be owned by one family or by one family and farming relatives. Again, debt's not over $10 million. At least 50% of the debt is farm related, and the corporation is not publicly traded. Chapter 12s are fun because not only can you continue with the existing farming operations, but you can, the debtors can get creative and have options of what they want to do, as long as they will have the ability to pay at least the secured and priority debt, if not something to the unsecured creditors. I've had one farm that sold their dairy cows prior to filing, and they're now doing a combination of selling hay, corn, and beef and other crops, as well as renting their 2 barns. I had one client last year which went from a conventional dairy to a goat dairy. It used to be that Chapter 12s were used to convert from conventional dairy to organic, but the organic dairy market has been overloaded, and not many processors are purchasing new sources of organic milk. It can be from a dairy to a downsized homestead. You sell some of the land, you sell the cows, but you continue raising beef or doing some hay. It can go from poultry to beef, dairy to sheep. There's lots of wonderful things that Chapter 12s can be used for. The other thing which is sometimes used is where a borrower retains their home and ends up surrendering the balance of the real estate to the mortgage holder. So they still get the right to keep their home. They do have to pay the value of the home if there is no equity in it, but they do get to continue living in their homestead. And for some folks, that's really all they want to save.
Well, thank you, Rebecca. We'll move on now to the next slide, new farm crisis. There's been a downward cycle in farming over the last few years. Farming income reached high levels in 2010 to 2011, After that, farming income fell more than 34%, or 50 billion, after adjusting for inflation. And farm sector debt has reached levels near the peak of the late 70s and early 80s. And now that we've had low interest rates for a little while, but now with the reduced income and interest rates are going up after the pandemic, that suggests that some farmers might not be able to repay their debt in the future. So there are different types of Chapter 12 plans. One of them is the traditional reorganization. So the goals here would be to preserve the farm's nature and scale, keep the farm about as it is, but reduce overall debt service, increase efficiency, and return the farm to profitability. In many cases, this need stems from a specific event that disrupts finances, like could be a crop failure, could be drought, could be weather related, could be some kind of family problem. So the questions that come up in these kind of reorganizations are, is the farm still viable with the reorganization? And is the farm able to survive on the production costs versus what market prices are for the commodity or commodities that they are growing? The second type of a Chapter 12 plan is a downsizing and conversion to another type of farming. The goals in this type of Chapter 12 plan are to reduce the scale of the operation, convert to a different or more diverse production base, could be a dairy farm to a crop farm, or could be adding different crops, adding a more value-added asset to the mix. And the goal is a return to profitability. What we need to do in that case is to carefully assess the resources of the farm and what changes can be made to reduce debt and increase profitability. So the goals of this are, and the questions, will the surrender of unnecessary equipment, land, or livestock increase profitability and reduce debt service? And will changing from a strictly wholesale market like milk to a more diversified market like a farmer's market be cost effective, result in more revenue, and increase profitability? There's also a sale plan, and in this the goals are to save the home but sell the farmland, property, and livestock. The debtor maintains control over marketing and sale of the property, and they can take advantage of special tax rules on capital gains. So the key here is that the debtor no longer wishes to work the farm or no longer can work the farm. And the questions for this type of plan are, will the plan be better than a liquidation in a Chapter 7? Will it result in more for the unsecured creditors? Do the tax implications of a Chapter 12 sale compare with a Chapter 7 liquidation? And could a Chapter 12 plan facilitate the transfer of the farm to, say, a family member that wants to operate the farm? How Chapter 12 plans can help farm lenders. That's a big one for us as we deal with this on an ongoing basis. And outside of a reorganization, lenders have limited options. We can lend more money or we can repossess collateral. The bankruptcy reorganization process creates some other options. It's not just the farmer and the lender. The lender becomes part of a team exploring options that includes the debtor's attorney, farm consultants, the trustee, and the court. The reorganization process can provide needed structure, oversight, and especially accountability with the monthly reporting that comes in and the timeliness and time deadlines that come with a Chapter 12. We find that frequently we're working with borrowers, but they're unable to provide information to us that we need to do a restructure. And when they come under the purview of the bankruptcy court, they are forced to come up with the monthly reporting, the numbers that we need, and a feasible plan to continue the operation. And now I'll turn it over to Brittany for her comments.
When approaching Chapter 12, from a creditor's perspective, it's really important to realize the context of the creditor. And that is, a creditor is doing a business and their business is to make money. So they are extending credit. They are expecting a rate on that return and a particular interest rate that has been negotiated. And there are certain pieces of collateral that they have decided to take as security measures, security interests, in order to make sure that they are repaid should there be a default. So when a party goes into a Chapter 12 bankruptcy, they're still going to want to make sure that they have those same expectations, maybe tempered a bit, but those same expectations are there. At the end of the day, they want to be able to report a return on their investments to their powers that be. So a Chapter 12 plan, what the creditor is looking for is, one, clear treatment of their claims. They want to make certain that their contract is set forth appropriately, the terms of those contracts are as close to what they originally negotiated, and that there is going to be a clear treatment of how they're going to be repaid. They're looking to make sure that the values that are represented as to the collateral are there and that they are getting a fair interest rate, particularly if the debtor is seeking to modify the length of the terms or how much is being paid back and when it is being paid. Another very important piece that a lawyer and their clients that are a creditor is looking for is information regarding the status of the collateral. This is important for a number of reasons. Oftentimes, there hasn't been as good of an information flow leading up to the Chapter 12 bankruptcy. So there is a concern as to where is the collateral. This is really in particular a concern when you're dealing with animals or grain. And the lender wants to know, where is that collateral? Where is the item that I have loaned that money for? Where is it located? In part because they would like to make sure they have an ability to retrieve it should everything fail and they have to seek a writ of replevin to go grab the equipment. But also they want to know, is it being stored properly? Is it in fair condition? Is it in repair? If there's a repair, there's a number of other concerns that the creditor is going to have, such as mechanics liens or any other type of lien that might be overlaying or overriding their security interest. They're very, very interested in making sure it is in good repair and that it might not be in someone else's possession. That can cause problems not only in the terms of the agreement, but in their ability to retrieve it. And then certainly there is a concern about insurance coverage. Insurance coverage is so critical. That is because it is certainly a layup issue for a creditor on seeking relief from stay. If there isn't insurance, the debtor is really compromised. And it just prevents the creditor from being very concerned as to the care and maintenance and attention that that borrower has had as to their deal with the borrower. They're also looking in the plan to make sure it is going to be supported by accurate, timely, and complete monthly reports. This is important because they want to make sure that the debtor has done their homework and they know what they're expecting. But keep in mind that the creditor is also a business. And so they have to report to parties. They have to report accurate, timely, monthly reports. And they need to make sure that the money that they anticipate is coming in really is, and they know when to expect it. And then the final item that they're looking for is a feasible plan projection. And that is making sure that this is going to be a workable plan. So why is feasibility important? Proposing an unfeasible plan is a waste of resources. It's not just a waste of resources for the creditor who has to come in and challenge a plan and dispute why it's not working, but it's also very important for the farmer itself. The requirement for a feasible plan increases the likelihood that this plan will get liftoff and succeed and make it through the end. That's really the one common denominator that everybody in a Chapter 12 is looking for. Everyone wants to see that the ship is going to be sailing smoothly and the issues are corrected and everybody can expect to get a return on their investment. The bankruptcy code requires that plans are feasible for confirmation and that debtor will be able to make plan payments in the way that they project. So how do you get to this plan feasibility? This is a place for plan collaboration. It's an opportunity for the parties to work amongst themselves in order to get liftoff and come up with a plan that's going to be workable for everybody. This can be a bit of a challenge because, as anybody who's been in a creditor context, there is a bit of an exhaustion level that is reached when a debtor is going into default and certainly into a bankruptcy. The lender has reached exhaustion, the farmer has reached exhaustion. There are a lot of other overlays of issues and concerns. But if the parties can move past that exhaustion and frustration level, and maybe that's where the lawyers can come in and start having discussions, that can be really valuable for the parties. If you can negotiate with some of the key creditors, that can really assist in minimizing the likelihood of objections. It can also provide an assessment by the debtor as to where is the creditor going. Not all creditors are treated the same. Some creditors have reporting authorities and SBA guarantees, FDIC insurance and audits that really narrow what they can do in having a creative license in order to help the debtor reorganize. Other creditors may not have the same goals of maintaining the same terms of their loan. They may be looking for other interesting or creative solutions in order for them to get the return on the investment that they provided. And this discussion amongst the council, amongst the parties, can really provide the opportunity to really understand where are everybody's goals in getting across the finish line for a plan. So soliciting input from the creditors' representatives can be super useful before you're even in the bankruptcy. This can limit the number of surprises or heated questions in a 341 meeting. Many of the debtors that I work with are very good about disclosing the condition of the equipment, the insurance coverage, information well before the 341 meeting. And that's also because the less questions that are asked, that prevents more other questions being inspired by other parties that are in attendance for the 341 meeting. It also allows the parties to have a good working relationship going into the plan and could minimize the desire to file a plan objection. If you're able to gather some good, solid data and build a plan that sets reasonable expectations for all the parties, including the debtor along with the creditor, that can really achieve some excellent goals. It also helps parties understand what they're going to need to put in their proof. A feasibility challenge is really an argument, is an evidentiary hearing. And when you have an evidentiary hearing, there are cost overlays for both parties. And that's where parties need to look at, are we going to need an expert? Is there an issue with somatic cell count? Is there an issue with the crops? What is the problem and who's going to explain those problems? And that is where experts or other lenders or some valuation expert are going to need to come in and provide evidence as to what is happening and why the plan is going to work. So building a feasible plan and the projection basis is really important, not just to the debtor, not to just the creditor, but also to the judge. The very best Chapter 12 cases that I have been involved with and where feasibility has been a focus is where the judge has simply asked, how do I know we're going to be better now than where we started? Some debtors are much better at covering this than others. Although a disclosure statement is not required in a Chapter 12, some of the really great Chapter 12 debtor counsel do provide a disclosure statement and a write-up. And that is a guidepost of where the trial will go on feasibility. They will cover what will the farm produce. They will cover how much will it produce. Why will it cost the money to do so? Why are these questions important? Well, it's important to understand What was the farm doing before the bankruptcy was filed? What got the farmer into trouble in the first place? And why is that going to change? If they are shifting gears entirely on what they're producing, what the farm is doing, that could have a significant impact on how the creditor analyzed providing the loan in the first place and their expectation of the return on the investment. If there is going to be a change in what is being produced, there's likely going to be a change in the cost of what's being produced. There also could be a changes into the cash flow. Maybe some of the loans and how the farmer was operating originally was on a milk check and they were expecting regular milk check payments. If they are going to shut down milking and switch over to grains or to beef cattle, well, that's not a monthly income, so to speak. And so they are very much interested in understanding how that cash flow will come in and how those prices will cover for the debtor. So all of these are questions that are going to come up in an evidentiary hearing for a Chapter 12, but they're really great questions to think about well before the filing of the Chapter 12 or before the plan is proposed. And the more that the debtor and the creditor can communicate and come up with creative solutions that make all of the parties happy is critical. And the one last and final piece of advice that can be provided to a debtor when working with a creditor is most of my creditor clients want to know, what is in it for me if I give this one last chance? Why should I give this opportunity again? And that's a good way to answer it. The answer would be because you will get your return on your investment. And if things aren't going to work as we predict, negotiating a outcome in the plan terms, whether it be an immediate relief from stay or knowing how the plan will land if there is a default, so that there's an expectation of outcome and predictability for the creditor, will go a very long way in getting their acceptance and willingness to cooperate with a confirmed Chapter 12 plan.
This concludes our presentation on farm reorganizations under Chapter 12 of the Bankruptcy Code. We hope you found this information useful and can carry it forward with you in your work. If you have any follow-up questions for any of the panelists or about the information provided here, please do contact us. We look forward to hearing from you.